Okay. All right, everybody, that's welcome tonight to the StratiVentures industry webinar. We have special guests here from BMW LAW, Banahan, Martinez, and Weatherford, and they have first names, right? You know, attorneys always put the last names into the nameplate, but we're gonna get to know you a little better, guys. Welcome this evening. We're gonna be identifying issues from contract to closing. So everybody that's joining us this evening, please feel free to just stand by for a little bit. We're gonna let some more people join in. As we know in real estate, we always give about a 5-minute window, right? Because, right, Alex, have you ever noticed that in real estate, there's always that nobody's on time?
I have, you know, and sometimes we get calls, can I come in tomorrow? Well, we're supposed to close at 2, but
Yeah.
Sure, come on in tomorrow.
Yeah.
We'll figure it out.
Right, right. So everybody that's joining us this evening, welcome. Let's see, participants, great. We've got a lot of people that are joining us. We've got Dr. Wallace, welcome, sir, joining us from Tampa. Roya joining us. She actually visited us from California this past week. Let's see here. Salvatore, Miss Sandra, Sunny Mills, welcome. If you want to go ahead and put in the chat, let us know where you guys are joining us from. Feel free to go ahead and do that. Let's see, Lisa Simmons, Carla Cleverman, welcome. Jeff Whittaker, welcome, sir. You and I still need to catch up to get you set up from your basics. Herman, thank you, sir. Dominic Robinson, Debbie, welcome. Bliss, welcome. Ooh, we've got Los Angeles, Woodbridge, Virginia, Houston, Texas. Now, you guys only practice in the state of Texas, right, Alex? Am I correct?
That's correct. We're only licensed in Texas.
Only licensed in Texas.
But we can close and do work all over the state.
Okay, perfect, perfect. But everybody, you're gonna still hear great information, and this might pique questions that you might be able to ask a real estate professional in your local area. Okay, so let's go ahead and get the ball rolling here. All right, everybody, welcome to tonight's webinar, identifying issues from contract to closing. Tonight's webinar is a StratiVentures webinar that we do every 2 weeks, so we like to have those twice a month. And we do this as an industry and community feature because we'd like to give back to the real estate investment community. Here's tonight's webinar time slots. We'll get started right at around 6:35, which is in about 2 minutes. And then I'll be handing that off to you guys there at BMW LAW. For those of you joining us in Zoom, remember we have the Q&A, we've got the questions. So please put all your questions in the Q&A, and we're gonna be answering those right at the end of their presentation. We don't have any polls this evening. And if you have questions to the moderator, which is Oriana Valles, she's our social media manager, please put those into the chat box. But all of your topic questions, put those into the Q&A. And if Alex becomes very boring, just kidding, or Diego becomes very boring, just hit the end button and we'll see you guys next time. It's not gonna be you guys, it's probably gonna be me, right? And this event is for you, so we really encourage questions. The purpose of this is to make sure you guys value the time, value the people that are speaking tonight, and one of the best things in rewards is questions, because they love to answer questions. A little bit about my company, StratiVentures, was established in May of 2012, and we quickly became a full-service real estate investing company with the 4 prongs that we like to say: acquisition analysis, real estate services, project management services, and last but not least, funding. So to get to know a little bit more about us and what we do, feel free to go to StratiVentures.com. There's a great video in the membership and company details. It's about 35 minutes long, but trust me, guys, you're gonna receive all that information and know exactly what we do and how we can help you guys. Here's the core team of SVI. We've got, obviously, myself, the guy that's talking right now. We have Oriana Valles, Maria Rodriguez, Selection and Design. Pedro Alcedo is our National Sales Director. Eric Christie is what we like to call our resident home inspector. He does not work for StratiVentures, but he is an inspector that gives a lot of his time and benefit to our SBI members. And we have Stacy Ford, she's our real estate services director, and Ron Dancy, who handles anything architectural. Myself, Diego here, born in Colombia, South America, came to the United States at the age of 4, live here in Houston, and had prior financial experience before investing in 2012. And I founded my company in 2012 in May and developed the current SBI platform, which is today in 2014. And that's something I love sharing with people, but give us a call, send us an email on one-on-ones, and guess what? You're really gonna see where the bread and butter and the magic of SBI comes to life. In June of 2012, guys, we launched our national platform because guess what happened in 2012? COVID, right? So everybody was locked in, had to move things into the online platform, which really broke the fence in the backyard down, and now the rest of the country is part of SBI. We're in over 27 states, over 2,300 members nationally and growing. And we have a company motto that we like to say, it's a win-win or we don't do it. That means everybody has to benefit from this. And last but not least, we have what we like to call the identity of what SBI thinks an investor is. You can ask 5 people, guys, the same question, what does a real estate investor do? And you're gonna get 5 different answers. And no pun intended here, all right, guys, over there at BMW? You know how they say, ask one question to 5 attorneys, you get 5 different answers? It's kind of the same thing in real estate. When you have too many people under different identities and needs and wants and drives and risk levels, you're part of a very volatile industry. So at SBI, the one identity that every member has is that they analyze, they act, they invest, and they profit with one word in mind, and that word is risk. So again, we like sharing, we love talking to new people and letting them know what we do. And if you need more information, feel free to just scan that QR code there and know more about StratiVentures. But tonight, it's not about StratiVentures, it's about BMW LAW and the great people that work there. So tonight we're going to be hearing from Veronica Martinez, Alex Weatherford, and Meg Banahan, right? Did I get that right?
That's right.
Okay, good. And so guys, they are a professional real estate minded attorney firm. And again, you can never have enough support, especially on the legal side. So please ask questions. This is definitely for you guys. So I'm going to go ahead, Alex, welcome this evening, and I'm going to disengage from the presentation and then move directly into yours.
You do it?
Yep.
Can you see the screen?
Looking good. Yes, sir.
Okay. So thank you, Diego. I appreciate it, and I appreciate you inviting us on. For everybody out there, it is Banahan, Martinez, Weatherford, BMW LAW. We kind of did it on purpose. So if one of us drops out, it's going to be something completely different. No more BMW cars. All that goes right out the window. So, but yeah, we're kind of two offices in one. One of them is a fee office of American Title, and then we are BMW LAW Legal Services. So the good thing about it is if one kind of feeds the other. If someone comes in with a problem and it just happens to be with real estate in mind, then we can help them out with title insurance if that's what needs to happen. On the flip side, if someone comes in and says, well, I have a problem with something that was fine on title commitment, we don't know who it is, BMW LAW can step in and fix all the kind of little legalities of it. So that's our firm there. See the tall one is Meg. And you see Veronica right there. And then the guy sitting down is me. The ladies from left to right are Jessica, Jeanette, Jenny, and Jennifer. We call them the J's. So if you guys have anyone looking for a job, make sure that they call us. If their first name starts with a J, we will.
It's a job requirement.
Yeah, it's a job requirement at this point.
I love it.
So just there on the bottom right, residential and commercial closing transactions. We do represent investors. Kind of our niche is we represent investors, flippers, builders. So we do cash deals, third-party finance, subject to just about anything that's creative financing, we can probably take care of it. And then along with that, if any issues come up, we can file suit if necessary. And then if you guys are out there, if you're builders or you own your own business and someone's not paying you or reach some kind of contract, we can also handle those types of claims in the state of Texas, of course. And if it's anywhere else, you can call us and I can say, well, not here, but here's what I would do if you were in Texas. So talking is always free. So here, the first thing we kind of want to talk about with tonight's presentation is when you're buying a property, are you going to buy it, especially as a business, you really shouldn't be buying it in your own name, right? You should have some kind of business entity set up and ready to go. But two of the most common questions that we have and the errors that people come in with entities are, they think they have an LLC, but then someone told them they're an S Corp. They're not quite sure what it is. And so I think what the confusion is there's two different things. Us as attorneys, we are probably only interested in making sure that you're legally protected from any liability. So if you come in and you want to start Alex LLC, say, okay, we can start that. Now I say to you, make sure you go and talk to your accountant and get the best tax treatment for you. And so we don't get into your finances, right? So when you go and talk to your accountant, he might say, oh, it's a flow through entity, or it's a partnership or an LP or a C Corp, S Corp. But that's a decision that you make based on your own finances and how you're going to run your operation, right? So then when you come, another thing when people come in, they say, no, I have a company, I have an LLC, don't worry about it. So we look it up and it turns out it's not, it's an assumed name, a DBA, and a DBA/assumed name, it's nothing, right? If you're wearing a paper bag over your head, someone can still hurt you when they hit you in the face, right? So when you have a business entity, it's like wearing a helmet, right? They can't get to your flesh. So having a DBA, sole proprietorship, I get it, right? Some people say to do it. I don't, because you're putting all your personal assets out on the front porch and you're saying, come get them. And if you have an attorney that's any good, they'll find your assets. And I'm that kind of attorney. So I've found people's assets and I've taken people's assets to pay off judgments and liabilities. So just make sure you have an entity that's out there. I mean, that you created. I used to say you can go ahead and sign your contract, and then between signing the contract and closing, you can probably start an LLC. But now the Texas Secretary of State is taking so long that I don't say that anymore. Ever since COVID, they've taken a few. I mean, it went from a couple days to 10, 14 days. Well, that's iffy, right? So then the other thing is when let's say that you decide you get an LLC, you come and you say, okay, I'm going to sign this contract, and you end up signing it in your name. You forget to put the LLC down. Well, it's a big deal because the contract says it's going to be you. And unless you have a buyer or a seller that's okay with you changing it at the last minute or whatever else, you're going to have to buy it in your own name instead of the LLC. So make sure that once you get your LLC, you have your tax treatment correctly, you know who's going to sign for what. Make sure that you follow the corporate formalities when you're operating your company, right? Get yourself a company agreement. Make sure that you have an EIN, right? Those you can get those in about 5-10 minutes. And then once you're doing all that and you're following your corporate formalities, don't commingle money, right? So if you're working, let's say you're working a job and you're getting a paycheck, right? And it's coming into your bank account, but you're also running Alex LLC, and you have rental payments coming in, or you bought a house and you put money in there, but then all of a sudden you're using that bank account to pay for your own personal bills. Fine, right? As long as you don't get caught doing it, it's fine. But it's when you get caught doing it that everything kind of crumbles. And again, if an attorney like me, that files a lawsuit against that LLC and they find while going through your financials that you've been paying a lot of personal bills and using it as your own little credit card, your little cash machine, instead of following the corporate formalities, then then it's a pass-through entity. It's as if it's not there. It's like the LLC did not exist and they can go after your personal assets. So make sure that when you have two bank accounts, keep them separate. If you need money to go from the LLC to you, do a distribution or talk to your accountant and see what's the best way to do it. Maybe you should be an employee of your entity, or maybe you just take out a distribution. It's depending on what it is. When you go sign the contract, if you see here on the bottom right, it says corporate formalities, Jones Premier Investors LLC by Tom Jones, President. It's important that it says that. If you forget the top line and it just says Tom Jones just bought it. If you don't say president, if you don't have the consent form from the company, it's as if it didn't happen again, right? So make sure you do that. Once you guys get going, right? So if you have one property, you have one LLC, it's a rental, it's great. But then all of a sudden you're doing fix and flips and you're lending money and you're doing just other asset holding, and you have it all under one LLC in order to protect your assets and the assets of your companies and all this hard work you're putting in. What you would like to do is then you start beginning to build a kind of a corporate umbrella. So you'll have a holding company at the top that does nothing but hold your interest or property. So it would be me, Alex Weatherford, individually, owned 100%, Alex LLC. I'm going to do rentals with Alex 1 LLC. My holding company owns that 100%. I do fix and flips with Alex 2. My holding company owns that. And then I'm lending money with Alex 3. My holding company owns that. The holding company up top does nothing but hold assets. It doesn't sign contracts. It doesn't get into anything where it can be held liable for any reason or any dollar amount. It's all your other entities that are owned by your holding company that are doing everything. We're going too slow. Sorry. The other thing, when you're signing a contract, make sure that your LLC is in good standing, right? If you go on to the first thing that people, when they come in and they give us a contract, Alex LLC, we get onto the Texas Secretary of State and Texas Comptroller, and it'll tell us whether you're allowed to do business in Texas. And if you're not, if your entity is not, the person who is running that entity is now on the hook personally for any contracts or any liabilities that are owed by the LLC while it was out of franchise tax status. So make sure that you keep up with your public information report in Texas. It's a PIR. Your accountant will probably do it if you're doing it. If not, you do it yourself. You can download it from, it's a form, Texas Secretary of State forms. Send it, fill it out, send it in. It's really easy. Let's see.
And Alex, can I ask you one question?
Yes.
Just so that we don't stay on topic with that one. Same as an entity.
I dropped you. I couldn't hear what your question was.
A lot of people say that a DBA is the same as an entity. What's the difference? I mean, in the severity of it, right?
I'm sorry, I'm not catching what you're saying, but I think your question is, what's the difference between a DBA and an entity?
Yes.
The difference is, a DBA is to me, it's nothing. All you're doing is you're saying the public face of Alex Weatherford is Alex Ventures, right? So when I sign a contract with Alex Ventures and someone comes to sue me, they're going to say, oh, that isn't a company. That's an assumed name. They go on to the county records, they find out who you are, and they sue you individually. That same contract, but I have an LLC or a corporation or some other entity, call it Alex Ventures LLC or Alex Ventures Co. They go to sue, they can look me up in the Texas Secretary of State. They see, oh, there he is. There's his registered agent. Now they're suing the company. They're not suing me individually. And that's the difference. It's protection of assets. To me, it's huge. So, and it should be to your clients, especially if they're building up a big asset base or they have a lot of assets and money that's in one place. They got to move that around. So that answer your question, all right?
Yes, you did.
Okay, perfect. So, okay, moving on to the common issues with the actual contract. So at the very top where the buyer will put Alex LLC, he puts and or assigns. You got to make sure that as a seller, you're okay with that, right? If you're making the sale to Alex LLC, you don't want to be caught asking questions why there's these other names on the contract or the deed, and it finds out that later on in the contract that he put Alex LLC and or assigns, and he assigned the contract to somebody else, right? And on the flip side of that, if you want to allow it, then you put it on there and you just make sure that prior to it, there is an assignment of the contract. Yeah, if you're a buyer especially. Due diligence and option periods. I'll tell you that some of the ugliest arguments that I've seen are these right here, the due diligence and option periods, because either the buyer seller are friendly or the agents are friendly, and they say, oh, don't worry about it, just put 10 days there and we'll figure it out as we go. Well, 10th day comes, somebody wants to back out, and then you can't get a hold of them, or they say, no, you can't back out, it was supposed to be yesterday. There's all kinds of things happen. And then as a buyer, if you say, well, I'm going to buy the house for, let's say, $300,000, you give yourself a very small amount of time. And at the last minute, you say, oh, you know what? 300,000 is too much. I want to get out of this. If you did not leave yourself an out, you're either going to buy a lawsuit, you're going to buy the house for $300,000, or just hope and pray that the seller is nice enough to either let you out of it or renegotiate the contract. So just make sure that when you're filling out the contract, you allow yourself enough time to do inspections, right? So in your area, wherever you are, if you know that it's going to take you a month to have an inspector come out, or 3 weeks to get a survey done, and you need a survey, don't give yourself 10 days, right? Give yourself enough time to get everything done. Leaving blanks or terms out, that's pretty big. We've had people come in that say, well, I thought they were paying all the closing costs. Well, I'm okay with that, but are you sure the other side was okay with it? And they say yes. You talk to the other side, they say no, I never said that. So you got to make sure that you look at the four corners of the document. If it says, if there's any special provision, put it there. If anything else in the contract, if you're using a check contract, there's a bunch of things that you need to fill out. Make sure you fill them out, right? They're there for a reason. Not including proper parties. I mean, that's by that, I think you mean the seller, right? If I put my name on the contract as Alex Weatherford, but the property is owned by me and brother and sister, or a corporation, or a trust, or I'm not quite sure who owns it, right? I think I own it, so I put my name on it. And then you go to the title company and we start figuring out that, wait, maybe Alex isn't the right person to be selling this property. And then we need to go fix that. Who pays closing costs? This is a kind of a big deal, especially around here, right? So you have buyers and sellers kind of, just kind of going, selling, buying properties, and then figure out that, no, you said you're going to pay closing costs. No, I said I was going to, no, you said. And so they're going back and forth. Just make sure that wherever it is in there, just make sure you put in a closing costs are going to be paid by who, or they're going to be split, or whatever it is. Just make sure it's in there in your contract, especially if you're using a homemade contract. And then closing date, not realistic. I think that goes back to the due diligence and option periods. If you're going to want a survey, if you want an inspection, there's an HOA, there's money that's owed on the house, all those things take time to resolve. So if you sign today and you want to close in 3 days, we will try as hard. I mean, we've bent over backwards here because we know that the business moves fast, but there are some things that are completely unrealistic, not because we won't move, but because you cannot get answers. You cannot get things done in the amount of time. So if you put a short closing date, make sure you give yourself a tickler on the calendar so that you can try to get it signed to extend that deadline to close. Oh, I think I talked about all this, right? Property description. Now this is just part of the contract. Parties' names, assigns, legal description. Make sure you fill all that out. and then the type of transaction. If you're going to buy a cash order and finance, make sure you have the addendum, or if you have a homemade contract, put it on there in there somewhere. Make sure you tell everyone if it's a subject to, if there's any special provisions. I know in TREC towards the end, there's about a paragraph that big, but there's not always in a space on there, right? So if you can't get it in there, attach a document to it, attach a blank piece of paper that everyone signs, and they acknowledge that these special provisions are a part of the sale, and you can move forward with that. But TREC does have a bunch of addendums if you want to use those. So I'll pass it to Veronica Martinez.
Hello, everyone. Good evening. Okay, so I'm just going to get into it really quickly here. Thank you, Alex, for taking extra time. All right, I'm kidding. Okay. All right. One of the most common issues that we see in our law practice is people coming in to fix their title issues that could have been avoided had they gotten title insurance. They would have been discovered at that time by the title company. So not getting title insurance is a huge, huge mistake. And another mistake is when you do decide, when you're signing the contract, the savvy investor is always going to want to get title insurance, but sometimes we just don't understand what it is. So when you go to a title company and you're closing with the title company, really what you're getting is title insurance. And title insurance is just an indemnity contract. It protects you, the insured, from losses arising from a real estate transaction against a loss that results from a defect in title. I know that's a mouthful, but it's important, right? Because that's what it is. It's a contract. It's a contract of indemnity. And really the only party to that contract is the title company. And I'll say more about that later on. But what's important about the title policy is that it is subject to exceptions, exclusions, and terms and conditions. And it is very important that you know what these are, right? And title companies, before they issue their title policy, and once you've turned in your contract to the title company, they open title. That's what it's called in the industry, right? So you should always decide. Let me just back up here and say, always decide to get title insurance. As a buyer, it is very important that you protect your asset, protected from errors that can happen, not after you've owned the property, but could be in the back, in the past, in the chain of title with somebody else. I mean, it could be like 50 years ago that there was a problem in the chain of title. Well, if you've gotten title insurance, you're protected. You can file a claim against that title insurance, and your ownership in that asset is protected. So before the title company issues its final title policy, which will happen after closing, they will give you a title commitment. I think most of you will be familiar with what a title commitment looks like, but let's just go over a few basics. A title commitment has 4 schedules: Schedule A, Schedule B, C, and D. And Schedule A, if you can see, it's just a summary of your transaction. That's exactly what it does. It sets out the type of transaction that is going to be insured. So in this case, in the example that we have, if you look at item number 1, you have the proposed insured is Investor Properties LLC right there. And Investor Properties is buying this property for $85,000. And if you go to item number, the next number, C, you see that Investor Properties is not getting a loan. Investor Properties is purchasing this property for cash. So in this particular case, there will only be an owner's policy, not a loan policy. Okay, so Schedule A also tells you who owns the property. Number 3, item number 3, this is very important for you to know to look at as a buyer of the property. You want to make sure that you're contracting with the right party, one of the issues that Alex addressed. And the next item, item number 4, last one on Schedule A, is the legal description to the property. Title companies do not insure property by address. They insure by legal description, lot and block, and subdivision in county. This is a lot and block legal description. There's another type of legal description, which is the long one, which we call the meets and bounds description. We have a lot and block right here. The next page is Schedule B. So Schedule B, this is very important, because remember in the definition that I said it's going to protect you against losses that result from a defect in title, but subject to the exceptions and exclusions from coverage. And those are going to be contained in Schedule B. And I didn't the title commitment actually is some of it is standard and some of it is a portion of it is specific. So I only have here item number 2 because I want to specifically talk about it, right? But you have from items 1 through 10, these are standard. If you go look at a commitment, that's just promulgated language by the state of Texas or the Department of Insurance. But item number 2, I want to address it because it has to do with the survey. Another mistake, right, that sometimes people make, especially when you're buying in rural areas or in unplatted subdivisions, you really want to get a survey, because your title policy is not going to protect you against discrepancies, conflicts, or shortages in area or boundary lines, or any encroachment or protrusion or any overlapping of improvements. I could tell you stories of people coming to us to represent them because they bought a property and the half of the house is encroaching on the neighbor's property, or the driveway. And so had you gotten a survey, you would have known, it would have shown that, right? You may not want the coverage. I always recommend that you get the coverage. If you get the coverage, it is called the survey deletion in the industry. And what that does, it eliminates everything from item number 2, except for shortages in area. So it'll protect you. If you get the survey deletion, you'll be protected from everything in here that is not shown on a survey, except for shortages in area. And I've included under item number 10 because so anything above 10 on the title commitment is standard, promulgated language. Anything below item number 10 is specific to your property. Very important that you look at this. Here, what you're going to see is oil and gas leases, mineral leases, which are the same, right? You're going to see that is filed in the real property records affecting this property. Leases, if the property is if there is a deed restrictions, will also commonly be on here. If there is an HOA, it'll be stated in here as well. Anything. If there is a contract that has been a memorandum of contract that is been filed and this transaction has closed before with this memorandum of contract, sometimes title companies will put it on Schedule B, right? Because it is specific to this transaction, and the title policy will not move it from Schedule B. So be sure to look at Schedule B, because these are your exclusions and your exceptions from coverage. Okay, so moving on to Schedule C. Schedule C is the big one. This is where we spend our time as a title company. As your escrow officers, we are spending most of our time here because this is what discloses the issues, right? The issues that are affecting the property. It matters that you look at it before closing and that you understand it, right? And again, part of Schedule C is also standard. And I think that after like item number 7 or 8 is going to be specific to your transaction. What are you going to see on Schedule C? You're going to see if there are any liens that are attaching to the property. If there are any probate issues, those might be disclosed in here. If there are judgments against you, if there's bankruptcies against, against the individuals involved or the sellers, even the buyers. Title companies also search the buyers. So all of those stuff, those items are listed on Schedule C. If they're not taken care of, guess what? You guessed right. They're going to be moved to Schedule B because the title company is not to insure those items, right? So they're going to be moved to Schedule B as an exception to title, not automatically, as escrow officers. For example, when you buy property subject to, Schedule C will list that mortgage that you're taking, that you're buying subject to. We have to talk to our underwriter and get their permission and their approval. They have to agree to insure this transaction subject to the lien, and then we have it moved to Schedule B, and then you have to acknowledge the receipt of that transaction. Okay, well, that's Schedule C. Look at it, is very important. Next item, well, the next schedule is Schedule D. And Schedule D, it's really just lists who the parties are, and it also sets out who gets part of the premium, of the title insurance premium. Okay, the title commitment, once it's issued, is only good for 90 days from the effective date. So, a lot of times you receive a title commitment and you sell your contract to an end buyer. You want to be sure, if you're an end buyer, that you have a good and valid commitment, because sometimes the wholesaler might hang on to that commitment for a long time because he's clearing title issues. So look at that as well. That's important. And then another thing that I want to say is that really the title company is not obligated to share its search, to share its title commitment with any other parties. It does this search for its own benefit, right? For its own benefit, and not of you, the party that is seeking to be insured. But we, as part of our customer service, most of us will share it. Everyone will share it with you so that you know what your title policy is going to look like. And then I'm going to pass it on to Meg. Meg is going to start talking about these other title issues.
All right.
Yeah, that's good. Yeah, so I'm going to go over just a few of the probably most common title issues that we see and work on and fix. I think one of the good things about our office is that we do have 3 attorneys on staff. We have a great relationship with our underwriters, and so we enjoy fixing title issues, and we do it a lot. So our investors seem to find these messy properties that come with these issues. And one of the biggest ones that we deal with is when there's deceased owners in title. And so, that's, you get into inheritance, lots of heirs, probates, things like that, but that's a big one. And then the next one is just mistakes in the chain of title. So maybe the previous owners didn't close with the title company or didn't get attorneys to prepare their documents. So they made mistakes, the names of the parties or the legal description was incorrect, things like that in the chain of title that have to get cured. And then the last one that we see a lot is just various liens, whether it's on the seller, the lien, or it could be a prior owner. So talking about deceased owners, here in Texas, if someone dies and they don't have a will, it's what we call intestacy. And then, the Texas Estate Code will tell you exactly who your heirs are, and it may not be who you want it to be. So the diagram over there on the right just kind of gives you an example of, say, like A is A is the last person that was entitled to the property. There's a deed into A, who is now deceased. A had 3 children, B, C, and D. A lot of times we'll get a contract from living child, C, who thinks, hey, I've lived in this property, you know, mom died, I'm the only living child, you know, it's mine. You know, they just assume it's theirs. They've been living there with no issues. And then they go to sell it. And we tell them, you know what? No, your nephew, you know, your nieces and nephews over there, they actually inherited an interest from your brother and sister. And you don't actually own the property. You own 1/3 of the property. And now you need to get, you know, these other people involved. So that happens a lot. This is actually a small diagram. We actually have some that go back several generations, and then we're talking about, you know, 20 plus different heirs that usually don't know each other, don't like each other, and don't want to all get involved and sell the property. But some ways that we can fix that, and probably the most common one, is the Affidavit of Heirship. So this is a non-court process. This is just a document that gets prepared by an attorney. It sets out the heirs in the document. So you have to go through the marital history, the children, you have to get lots of information, dates of birth, dates of death, who their children are, and that kind of thing, and put it all out in a document that gets signed by one of the heirs and then 2 disinterested witnesses. So 2, you know, it could be a friend, a neighbor, someone like that would also need to sign it, that knew the person that died and could say that the information contained in there is correct. There's some caveats to being able to use the Affidavit of Heirship. You need to have enough time has passed since the person died. So if they died last week and you go to sell the property, you know, that most underwriters are not going to allow an Affidavit of Heirship. Our underwriter usually requires that it's been 4 months. 4 to 6 months is pretty normal. So depending on the situation, you know, you may need to provide additional information, but I would just say, if this comes up, work with your title company or your attorney to try to see if this could resolve the issue. If the heirship affidavit doesn't work, there is a court process where you can get the heirs declared by a judge. So that might be something you would have to do, say, if enough time hasn't elapsed, or if you don't have enough information to where, you know, the attorney feels like you have a good enough heirship affidavit. Another court process is a small estate affidavit. That one's fairly specific because it usually just involves a homestead that gets inherited by a surviving spouse. But again, that's just a shorter process through the court. So some people do actually prepare and plan, and they have a will. You know, the will has to be admitted to probate for it to actually transfer title. Here in Texas, there's a few different ways you can do that. One is just a muniment of title. No administrator is going to be appointed. All you're doing is getting the will proven up at court so that it can transfer title to property. We do that one a lot. If there's a reason for an administration, you need to get the executor or the personal representative appointed. You can do an independent administration if the will allows for that, or a dependent administration, which means you have to get court approval for everything. I could go on and on about deceased owners and all the different variations. That's a whole nother hour-long presentation that we give. But one of the other things that comes up a lot is just names. Names are important. I think Alex kind of talked about it in as far as like DBAs or your company. But a lot of times the names on the documents in the chain of title are incorrect. This example that we have up here, it starts out in the first deed on the top left one, where the trust takes title. So Sue and Bob are the trustees of the trust. Trustees are the only, you know, they actually hold title to the property, not the trust. But when they went to sell the property, they said the grantor was Sue D. and Bob Seller Revocable Living Trust, which you'll see is different than the highlighted language above. So unfortunately, that would pop up on a title commitment, and that's something that needs to get corrected. And that can be done with a correction deed. So where you go in and you state why you're making the correction, and then you do it correctly. Depending on the type of error that it is, you know, it could be that you can do, you'll have to do like a a full correction deed and get both parties to sign, or, if it's not a material thing that's being corrected, it's just a typo or something, that can be done with an affidavit and just signed by one of the parties. But again, depending on how far back in the chain of title it goes, these can be hard things to get done because you have to find those people to get them to sign these documents. The next one would be the legal description, and we see this a lot. The legal description you see on the left that says incorrect is, I'm guessing, pulled straight from the appraisal district. You'll see how short it is because they're putting it on their website, their documents, and they're not going to type out the long legal description. A lot of times when people are doing their own documents, they'll just pull that legal description from the appraisal district, put it on their deed, and then later on they'll find out when they go to sell that that's not, insurable. So our underwriters will put on Schedule C that the legal description is incorrect. You'll see on the right side, that's the correct legal description. This is one of those meets and bounds that Veronica was talking about. You'll see that it's much longer. And so again, this will have to get corrected with a correction deed or a correction instrument, and it has to be signed by the parties from the original deed that was done incorrectly. This is another one we get a lot of. The last one that I'm going to talk about, and then we'll wrap it up for some questions here, is liens against the property. And typically there's, it'll be a homestead property that you're selling or maybe a non-homestead. And that makes a big difference because there's certain types of liens that can attach to a homestead as opposed to a non-homestead property. And there's ways that you can get, those homestead liens released without having to pay them off if it's a type of lien that is not allowable to be attached to the homestead. But that's a long process. It could involve a 30-day demand letter and then filing of affidavits and things like that. If it is a lien that's allowed to be on the property, then we have to get payoffs. Sometimes those payoffs can take up to a week to get back. So again, that goes back into your time frame of everything and whatnot. So that's, I believe, the last point we were going to make. This is just kind of some takeaways that we wanted to leave y'all with. I know it was a lot of information, but we just want you to know that, you need to know your corporate structure. You need to ensure that all the terms are in your contract. You need to notify your title company of any potential issues, hopefully when you give them the contract. A lot of our clients, they know they're dealing with messy title and they get as much information as possible when they're signing the contract to help speed things up. Always communicate with the seller, buyer, the other party about the title issues. And the last one, be kind to your attorney and closer. We want you to close your deal. Trust me, we want you to close your deal. We're not trying to be difficult, but at the same time, we want to ensure that it's a good deal when you walk out of our office and you're closed, that you're not going to come back griping about title issues that came up that we didn't fix. So.
Wow, absolutely. Can you guys hear me clearly there?
Yes, we can.
Perfect. All right, so there, ladies and gentlemen, this is the full contact information to get a hold of Alex, Veronica, and Meg at BMW Law. Like we stated earlier, feel free to type in those questions. We've got some questions, guys, that have come in. So I saw Veronica's eyebrows just went, uh-oh, we got some questions. So what's the best way for them to contact you? Is it through the webpage? Is there a chat, or is it email? Is it phone? What do you guys prefer?
Any of I think all the above. You could email us, or we're happy to take phone calls to kind of talk through. Sometimes it's easier than email, especially if it's kind of fact specific, which they usually are. Happy to just take a phone call or set up a time to discuss, the scenario, the issues with any one of us that's available. So to see how we can help you out.
Okay, well, great. Are you guys ready? We got some questions here.
Let's
All
go.
right, let's see. First one came in from Ms. Lisa Simmons that says, I have a contract with the seller and I filed a memo of contract. The seller signed a contract with a second buyer while my contract was active. The second buyer has asked me to release the MOC. I was closing this transaction with my willing seller on the first week of October. Is that second MOC valid? Is it necessary to have the buyer sign a release before I can close? So the two questions would be, is the second MOC valid, or does she have to sign a release?
So remember, it's all about title insurance, right? That's what a title company is going to do. So the title company, or what's reflected on Schedule C of the title commitment, are those instruments that affect the property. So if it was filed and it references the property, then it's attaching to the property. What did I say? If it's not taken care of, then it's going to be moved to Schedule B as an exception, or can be moved to Schedule B as an exception. So we don't determine whether or not it's valid, right? If you want to determine whether or not it's valid, well, that needs to be, that could be done by, you'll need the help of an attorney, right? And hopefully you don't have to file a lawsuit. But we find that a lot of times what they want is just, money,
Right.
And they'll go away.
Right. Well, thanks for answering that, Veronica. We have another question that says, are you willing on a double close to use the end buyer's funds to close on the first transaction? I know that was big back then, and now, guys.
We cannot, we are prohibited from doing that.
Good answer.
Rules prohibit that.
Here, Bliss Mitten, he's from the San Antonio market, asked, I was told that Trek contract is assignable as provided by Trek.
Well, most contracts are, right? Unless they're prohibited, unless there's a specific clause in the contract that says it's prohibited, then it's assignable. That's the short answer.
Yeah.
Perfect. Trek does not have a subject to addendum, do they?
No, no, they don't have a subject to addendum. And if you look at the purchase price section where you can kind of check the box, I think it has a checkbox for assumption, which is different. Owner finance and third-party finance. So what we would advise is that you put in the special provisions, that it's a subject to transaction, and that you do add that addendum with any, specific agreements regarding that subject to, as far as, how are you going to calculate the purchase price, et cetera.
Perfect. Thanks, Meg. Who chooses the title company for a typical single-family home transaction between Sam seller and Bob buyer?
Well, I think that the rule of thumb is whoever is paying for the title policy. I think that's although it's not a written rule, but typically that's the way it goes. I think that's the right answer there. Whoever pays for the title policy has the right to choose.
Perfect. Thanks, Jeff, for the good question. Roya Javid asked, what type of liens cannot be placed against the homestead?
So that would be a judgment lien for say credit card debt.
It's easier the other way.
Yeah, I was gonna say probably easier to say which ones can, there's 7. They can. Oh, well, I don't know all of them on there, but your mortgage, or if you have work done on your house, as long as it's done correctly, are the biggest ones that we see. Is it the mortgage, or a home equity loan, HOAs, taxes, federal taxes, I think. But yeah, but usually the ones that we see that don't attach to the homestead are usually your judgment liens. You got sued, you didn't pay your credit card debt. Those will be filed of record, but they don't actually attach to your homestead.
So that's make sure you kind of differentiate that, right? Anything can be filed against your property. Now, whether or not it's allowed, legal, or if you can enforce it, that's that's the no, right, for most of those.
And this is one aspect that we can, as a title company, get involved. We can help you with, if it's a lien against the homestead, we can determine that, and we'll help you through the process that is necessary to get it released. Like Meg said, it is a process that takes up to 30 days.
Okay, well, I have a question. Nowadays, a lot of the new construction that we're doing, because of city code and new updates, we have to make the homes solar panel ready. So we're hearing that if somebody puts or finances a solar panel, system, that these companies actually do have an ability to foreclose on properties. Am I correct to say that? Because they can lien that as the product is on the house, it's stuck to the property, so that technically can become an actionable event.
So it depends on,
UCC.
yeah, it depends on the UCC, but also if they sign their contract correctly, because if it's a homestead, in order for that lien to attach, it has to have been done with both parties. So let's say that husband and wife go, only the husband signs the contract with the solar panels, but it's owned by both. That's not going to attach, because you have to have it signed by both parties. There's some disclosures that you have to give. There are a lot of pages. I mean, all this stuff is in Chapter 53 Property Code. I mean, you can just copy and paste it if you're a contractor and get that done. So the answer is yes or no, right? If they do everything correctly, which these guys probably are on the ball because they don't want to lose all that money.
Mm-hmm.
But not everything that's attached to a home is enforceable, right? They have to jump through the hoops, and if they don't jump through those hoops, they just lost that. I mean, they lost
Can't
it.
do it. Awesome. Is it true that federal lending law limits the closing costs to no more than 8% of the loan amount?
Oh, boy, I don't know if it's 8%, but there is a limit. And it
Okay.
just depends on the loan amount and the, oh, my goodness, I just lost my train of thought. Here's my statement. Yeah, well, it depends on the transaction itself, and the value of the property, the income of the individual.
Okay. The second part of that question is closing cost including loan processing, legal fee, FedEx fee, and loan policy if this is a loan?
I don't know what she means. by loan
Yes.
processing.
Okay.
But yeah, that's
Lender
also-
fees.
Yes, all lender fees, legal fees, FedEx fees, courier fees. Yes,
Remote
these are all
notary.
part of the APR. Yes.
Okay. Let's see here. I paid cash for a rental property and refinanced under an LLC. One, that is owned 100% by a holding company. I'm not sure why a real estate tool is able to know that I'm an owner. Is it because I am the personal guarantee for the loan that is is that why my name is revealed?
So I'm not sure where they found your name, but if you give me the name of an LLC, you can go on to the Texas Secretary of State and find their filing documents, their yearly filing documents, who you put on as the managing partner, the president, all that. So if you disclose that on those documents, then that's where they're getting it from. And that takes less than a minute to find.
Yeah.
I don't know where, specifically to you, I don't know what the answer is, but if you put it on a piece of paper and put that in and filed that with the state in Texas, it's going to be shown to the public.
Got it. And Veronica, this next question, you may have covered it there. Can you include the results of a survey of the land to be covered by title insurance and where to put it? Says Schedule B or C for encroachment.
Can include the results of the survey of the land to be covered. I'm not sure what.
So so the results of the survey, it doesn't get put on Schedule B or C. The results of the survey allows things to be removed off of Schedule B that are then insurable.
So what the survey will do, if you buy the coverage, as I said, and that showed you in the slide, it's going to remove the encroachments. It's going to remove that general exception, except for shortages in area. If there are any encroachments that are shown on the survey, they will be shown on Schedule B, but under item number 10. So for example, a very common one is, fences never follow the property line. Very rarely do they do that. So that's going to be reflected, right? If any dispute that arises out of, the fact that the fence does not follow the property line, that's a typical encroachment or an exception that's going to be on there on the owner's policy. I'm not sure if I answered the question.
It's okay. I was a little also didn't quite understand it. Does BMW Law offer title insurance and/or escrow services as well as legal services?
Yes, we do. We do. As the law firm, we are a fee office of American Title, and we can close your transaction. And if you want title insurance, we can close it with title insurance. If you don't want title insurance for whatever good reason or not good reason, then we can do that too. We don't advise it, but sometimes we represent sellers and
Got it. Is a survey needed for every real estate transaction, or maybe after a few years since the last one?
No.
The answer to that is no, you never need one, right? Except if you're getting a loan from a traditional bank, they're going to require one. But if you're lending money and if you're buying a property, I think if you're in those two positions, you're probably smart enough to get one. Because if you don't, you're not quite sure what you're lending money on. If someone tells you, well, I'm buying a 2-acre piece of property, but you don't get a survey and it turns out it's a 1-acre piece of property. As a lender, your collateral just dropped. So
absolutely. And nowadays, some of the lenders are requiring those surveys to have GPS coordinates on there. And so that is going to be another. We've seen surveys that were brought to us for $450 go up to almost $750 because they have to go in and put the GPS coordinates. So that was a great question there, Jeff. Lisa asked, does a child support lien attach to a homestead?
It does, and a child support lien is one like you can't avoid it. So we've had, we've had people inherit property and say one of the heirs had a child support lien filed against them. Like they can't, transfer their inheritance or anything to try to avoid that. That's one that we always have to get a payoff for, or a partial. Sometimes they'll, if there's not enough proceeds to pay it all, they'll still allow you to sell it, but they'll take a lesser payoff to release the property. But yeah, child support liens. And so that's one where, so say you're trying, you're going to sell it. You have a child support lien against you. You can't be like, hey, I'm going to gift it over to Alex so that Alex can sell it, and he doesn't have that lien filed against him. The title company is going to go back and see that there was a prior owner and that there was a lien. It still stays with the property.
Okay. Thank you for answering that, Meg. Here it says, were you saying that to do a subject to, that you check the loan assumption box where the sales price goes, it would be cash?
No, that wasn't what I was saying. I was just pointing out that the TREC contract has a box to check assumption, and sometimes people check that box, but that's it. But an assumption is different than a subject to transaction. So if you're going to do a subject to and you're using the TREC contract, that's definitely a time where you need to add special provisions or an addendum to the contract.
Okay. What about judgments won for money owned? In other words, if somebody who owed me money and I go to court and I win, can this be put as a lien on the debtor's property in case of the debtor doesn't pay?
So if it's not the homestead, yes. So let's say so the interesting thing is when you have a judgment like that, and I've done this hundreds of times, I guess, you're not actually putting it against a specific piece of property. You file it in the county records. So if they have 5 properties in Harris County, you got a judgment against them in any county, you go to Harris County property records, you file your official order and judgment, and any property that's in that county that person owns in the specific name that's on the order, they will have a lien against that property. Now, if it's a homestead, it won't attach, but if they own 5 pieces of property, not all of them are homestead. So if you find that out, then you can go to you take that judgment, you go to the sheriff and you say, I want you to sell these houses so that you can pay off this loan, pay off this order, I'm sorry.
All right. Agnes asked, do title companies still have access to foreclosure and or short sale lists? What process do I need to do to get a title company to get me those lists?
I'm not aware that we did in the past, but we don't. I mean, do you know of any list that we have?
No.
I don't think we do. No.
There are some title companies that or other data companies that present the 30, 60, and 90-day late lists. And Agnes, I will tell you, just always be very leery and skeptical of data mining, because a lot of this information may not be scrubbed, or it may not be correct, or you go knock on the person's door and it's somebody completely different because things have been resolved. So just be very do your due diligence, right? At that point. Jeff asked, he says, apologies if this isn't germane, was it?
Germane, yeah.
Germane to the discussion, but legal stuff. So in the TREC seller's disclosure statement, it asked the seller to disclose certain conditions, including water damage not due to flood event. Would that means saying yes to any damage, even if it was fully repaired?
Yes. Yes, a million times yes. So I've been involved in a bunch of these lawsuits where this exact thing happened, right? You had a flood event, whether it's those last 5 years or not. They had a flood event, they completely renovated the house, everything was clean, but you still have to put it on the disclosure, because you have to give the buyer an opportunity to buy the house with the information provided by the seller, but all of that has to be truthful. So you can say to them, it's that little disclosure form, you can put on there, yes, it was, but then you can show, if you've done it, receipts of it all getting fixed, right? But then if they know, let's say it was a rain event, it came through the roof, you say, well, I replaced the roof. Well, now you can tell your inspector as the buyer, hey, I need you to pay a little more attention to the roof, or if it's the flooring or the walls or whatever else. But yes, even if you're the #1 floor guy out there and you fix the floors and everything's fine, put it on the disclosure.
Perfect.
It could be taken as you concealing information.
Yeah. Correct.
You don't want to conceal.
Now, and that opens up a whole other can of worms there.
Oh yeah.
Yeah.
For subject to, what box do you check in the sales price section of the TREC contract?
So remember, in the TREC contract, and with any contract, you always have the ability to cross out anything that doesn't apply. But if you're specifically talking about subject to, what we recommend that you do is add an addendum to the contract that sets out a formula so that we can calculate what the sales price is going to be. But what you do to tell the title company and the parties that it's a subject to, use your paragraph 11 of the TREC contract, which is your special provisions, and just plainly state that the buyer is purchasing the property subject to the existing mortgage. We need that language in the contract to close your subject to transaction. It specifically has to state that.
All right. Well, guys, we had a lot of good questions, and thank you so much for the information. I hope everything was good. Ladies and gentlemen, here is the full contact information for BMW LAW. Again, check out their webpage. I was looking at this today. It's great. Give them a call. Do you guys have any comments or any questions or things that you might want to say before we go ahead and close this out?
Oh, just please feel free to call us anytime. We don't charge for the just information, or just easy question we can answer. We're happy to help you out.
Got it. And one question always, I know a lot of the members at SVI ask, is what is your charge for pulling a title search?
So the title company, American Title, and per the rules, actually, under the Texas the title insurance rules, We cannot pull a title commitment for you unless it's part of a bona fide transaction, unless we have a real estate contract or there's going to be a refinance and we've got a request from a lender. But if you just want a title search on the property, we can do that for you on the side, on the law firm side. And we just go to a website and order a title report for you.
Okay, great.
Yeah, and it just varies depending on what type of title report and the purpose that you need it for.
Perfect. Thanks, Veronica. Guys, and we want to thank everybody that is joining us this evening. And thank you also all the SVI partners and affiliates. And we are inviting you, for those of you that are new to the SVI family, go ahead and go to StratiVentures.com and register for the free one-on-ones. And there we get to know each other. We get to find out more about what your needs and wants are. And a lot of that also may be something that might have to do with BMW Law, and we'll be happy to connect you with them. And also for those of you that are new investors and specifically realtors, ask us about our new basics program. This is a toolbox that was recently created that is going to give such an advantage to all of the realtors in the industry on how to work with investors. And also make sure you guys do join us if you're in Houston, October 11th at Quest Trust Building from 10 to 1. We're holding our Realtor Advantage training, and you can find more information about that at the StratiVentures.com webpage in the events button. So we welcome everybody to join us there if you're a realtor. That's something really special for you. And again, thanks for attending. Like and subscribe us on all these social media platforms. And also all SVI members, go to the member center, look for the network vendor tab, and there you're going to have all of the BMW full contact and information there because they have joined our family, guys. So we want to welcome y'all. And again, thank you so much. And everybody that's joining us this evening, enjoy your family and have a pleasant evening.
Thank you very
Diego.
much.
Thank
Have
you,
a great
Diego.
night. Bye-bye.
Bye, guys.